Well, the battle is not over on whether Utahns will be voting on Amendment D this November. Opponents say it would have allowed the legislature the ability to repeal laws created by citizens. The Utah Legislature is now asking the Utah Supreme Court to reverse a judge's decision that the Amendment D cannot be counted. News specialist Lindsay Ertz was one of the first to break this news today. And Lindsay, why does the state say that this should be overturned?
Yeah, Ashley, well, the Utah Legislature's lawyers here argue that this ballot question and this summary that will go on your ballot is not a basis for why this amendment should be overturned and voters should not be allowed to vote on it. They also maintain that they filled a publication requirement, and that was another one of the main reasons that a third district judge struck down this amendment from being voted on. Now, this is all over, again, this ballot language of how the question will appear on your ballot. That language says, should the Utah Constitution be changed to strengthen the initiative process, prohibiting foreign influence on ballot initiatives, referendums, and by clarifying that the voters and the legislative bodies have ability to amend laws. Now, yesterday, a judge ruled that that language was misleading because it didn't hit on the chief feature of the amendment. That, the judge says, was that it would give the legislature the ability to have the unlimited right to change laws passed by citizen initiative. Now, this appeal challenges whether the judge can void this language. Now, the lawyer for the groups who are suing, who don't want this on the ballot, are confident that the Utah Supreme Court will uphold the decision.
We think that what the district court did is not radical in any sense of the word. It is straight down the middle of our Constitution's promise that the people are sovereign and all power derives from them. And the Supreme Court affirmed that principle in this case just in July, and we think they'll do the same thing here.
Now, the appeal is asking the groups to respond by Tuesday and the Utah Supreme Court to weigh in by September 24th. Now, the legislature's lawyers argue that will be 6 weeks before the election. That, they say, would give voters enough time to study up on this issue before it hits your ballot if the Supreme Court revives it. We'll continue to follow these developments. Reporting live, I'm Lindsay Ertz. I'll send it back to you.